Thank you for joining our Lawyers for Learners presentation today on presidential pardons for the offense of simple possession of marijuana in terms of federal convictions. Today, you're joined with myself, Liam Coughlan, paralegal over at Legal Action, and then Megan Sprecher, the supervising attorney for the Student Legal Aid Project in the Madison office. As we discussed the presentation, there's going to be a lot of terminology used, including different terminology to describe marijuana, such as cannabis, THC, but in the interest of simplicity, we'll just use the term marijuana. Federal law still considers marijuana to be a Schedule I controlled substance, making it illegal to possess, distribute, or use under federal law. It additionally is considered to have no medical purpose or use, whereas state marijuana law varies widely, with some states legalizing it for medicinal purposes and others even for recreational use. However, in many states, such as Wisconsin, marijuana remains illegal. There are many courts that the enforcement of a marijuana conviction may go under. Municipal court may be an option for many. Municipal court here's cases where a person was cited for a non-criminal ordinance violation. Many municipalities have ordinances that will provide for a forfeiture for the possession of marijuana. There is no right to a court-appointed attorney for forfeiture cases. But additionally, there is no risk of imprisonment. And an example of that may be the Sun Prairie Municipal Court. Another type of court would be the circuit court. The county circuit court would hear the case where a person was charged under a criminal statute in the state of Wisconsin. Ordinance violations are also heard here under certain circumstances. An example of that may be the Brown County Circuit Court or the Waukesha County Circuit Court. And lastly, we end in federal court. Federal district courts will hear cases where a person was charged with a crime under federal law, such as the Eastern District of Wisconsin or the Western District of Wisconsin. Now, there is quite a wide disparity in terms of enforcement, with many counties and municipalities decriminalizing the possession and use of marijuana. Officers really have the discretion to issue these citations or warnings for minor offenses in a lot of these communities, whereas in other communities and with many state level law enforcement members, such as the State Patrol, they might not have those abilities or those opportunities for that type of discretion. So again, that enforcement varies widely. If you look here in Dane County, you can see that based off the population, enforcement's rather low in terms of actual criminal convictions, whereas in Brown County, where there may not exist the same level of decriminalization, even though they have a significantly lower population, we do see a much higher rate of criminal convictions in terms of marijuana. So personal possession in many of these areas, such as Dane County and specifically in the city of Madison, are essentially legalized or decriminalized, meaning there is no criminal implication to the possession of marijuana. However, as far as Dane County may go, there may be those ordinance or forfeiture violations that would result in a money penalty. So the research has shown that people of all races and ethnicities use cannabis at similar rates. However, enforcement, Black Americans are nearly 4 times more likely to be arrested for cannabis-related offenses. So unfortunately, enforcement is unequal in that regard.
Right, so I'll be talking to you about pardons for marijuana-related convictions. So at the state level, if it's a state conviction, which is most of the marijuana-related convictions that we'll see, to qualify for applying for a state pardon, you have to be seeking a pardon for a felony conviction. The only time that a misdemeanor conviction would be considered under the current eligibility criteria is if it is paired with a felony conviction. So if someone was convicted of a felony and a misdemeanor at the same time, the person cannot have any pending criminal cases or charges in any jurisdiction, even outside of Wisconsin. The person cannot be currently required to register as a sex offender, and it has to have been at least 5 years since the person finished any criminal sentence. So, any incarceration, any probation, the whole sentence has to have been completed at least 5 years ago. So that's for a state marijuana conviction of a felony. We also want to talk about a federal pardon for the offense of simple possession of marijuana, which has been in the news a lot lately. President Biden issued a blanket pardon for any U.S. citizen or lawful permanent resident or green card holder who is convicted of a simple marijuana possession in federal or D.C. Superior Court. The conviction has to have happened on or before October 6th of 2022. And the pardon is retroactive, it's automatic, and is applied to any eligible individual. So unlike the state pardon in Wisconsin, where you have to, proactively apply for a pardon, this pardon is automatic, retroactive, and individuals do not need to apply for anything to receive the pardon. They understand, the federal government, I think, understands that people will often need to have documentation of something like a pardon for potential employers, for potential landlords. And so people who qualify for this federal pardon are able to request a certificate of the pardon. So they don't have to. They are pardoned based on how the pardon was written on the federal level, but people who want proof of the pardon can request a certificate. The federal pardon does not apply to people who are convicted of other marijuana-related offenses. So things like trafficking, distribution, things like that were not included. It's a simple possession conviction that qualifies. So things to consider when figuring out if your marijuana-related conviction is in a municipal, state, or federal court. Consider who investigated the incident. Was it local law enforcement? Was it the FBI? Was it, like a park ranger on a national park? Was your appearance in court mandatory or non-mandatory? So if it was non-mandatory, if you could just pay a fine and not have to go to court, then that's a good indication that it is a non-criminal offense and likely was in municipal court or was a forfeiture that was heard in circuit court. Look at the paperwork and look to see what court is listed on that paperwork. Look to see if the conviction resulted in any jail time or probation. For state level offenses, CCAP, the online court record database, if the case is on CCAP, then it happened in a circuit court. So that's a good indication as well. If the offense occurred within the Wisconsin borders and was investigated by state or local authorities, it's likely going to be a state level offense. It's not going to be a federal offense. Offenses that involve large amounts of marijuana that cross state lines or occur on federal property, like a national park, those are the ones that might fall under federal law, federal jurisdiction. The jurisdictional issues can be complex and might involve overlapping laws, and sometimes in certain situations, the individual might be subject to both state and federal charges. So this is a flow chart to see if someone is eligible for the federal blanket pardon. So for a simple possession of marijuana offense, look to see, did the conviction occur in state circuit court? If yes, you're not eligible, then it might be a situation where you explore the state level pardon. If no, did the conviction occur in federal or DC Superior Court? If yes, are you a U.S. citizen or lawful permanent resident or green card holder at the time of the offense? If yes, again, were you a U.S. citizen or green card holder on October 6th of 2022? If yes, you are eligible. Some other options to consider if a federal pardon or a state pardon are not options, something to consider would be an expungement. So if someone is convicted of a state level misdemeanor crime or certain felonies, they can be eligible for expungement if they were under a certain age at the time of the incident. So age 21 or age 25, depending on the law at the time of the incident. and the judge ordered expungement at the time of sentencing. If a case is expunged in Wisconsin, the case comes off CCAP and the court records are sealed. It does not remove the arrest from the CIB background check, and it is still considered a conviction, but it is helpful certainly to have it removed from CCAP and to have it be expunged. In some situations, municipal verdicts can be reopened and vacated. So for citations or forfeitures, which took place in municipal court, and in some cases in circuit court, they can sometimes be reopened and vacated, which would remove the conviction. And then if the conviction is removed, that the corresponding data could be removed from the background check as well. The procedures and their discretion involved, and that does vary by court. So just to sum this up, Lawyers for Learners can help. We can potentially help with a state level pardon, applying for a federal pardon certificate, correcting and removing things from criminal background checks, and referrals for lots of other issues. So please check out the website at lawyersforlearners.org and fill out the intake form if you have any legal needs.